we've got a question. Do you want to, Mr. Producer, can we take the question now? Yes, we're going to take the question. Robert from Washington County, go ahead with your question, please.
Yes, I have a question about child support. I've been paying child support, since about in the early 80s. I'm 68 years old. My kids are grown, and I'm on disability, and they taking it out of my check. I want to know the statute of when the child support stopped. Actually, I found one of my children had found out was not one of mine, but they told me if they found out it's true, all that would be dead money.
Goodness, Robert. I don't know if everybody could hear Robert through the television there, but Robert has been paying child support, he says, from the 1980s. He's now in his 60s and on disability. When does his child support end? And Stan, I'll let you take a first crack at it, and I might fill in some gaps as well.
Very well. Robert, are your children either 18 or 19 years of age or older? And have they graduated from high school? That would be one of the first questions I would ask. Are your children over the age of 18 or 19?
Yes, they have grown and got children of their own. All of them are over 30.
Very good. That's what I thought based on the numbers and the years you were giving me. Do you have a copy of the actual judgment or document that divorced you back in the past?
That's been so long, but like I said, I talked to a friend of mine. They said this statute should have been dropped years ago, and they should have, stopped, the payment since then.
Based on the numbers you've given me, I would agree so. You can go to the courthouse that you obtained that judgment of or from. You can get a copy of that and consult with a lawyer about it. And the devil's always in the details. It's the language that controls many times. There are some people in Florida who sometimes will have their children set aside a college fund, for example, and they will order as part of their divorce that daddy or mama pay college fund for the children until they're 22 years of age. Is that legal? Sure, it's legal, but under Florida law, if there's a divorce that occurs and if those children reach the level of 18 to 19, if they're 18 and graduate from high school, then normally they are emancipated. They are considered to be adults. And from the Florida point of view, once you are emancipated, have a high school, or have completed high school before your 19th birthday, that emancipated adult is no longer the responsibility of his parents. And the parents have no financial legal obligation to be paying child support after high school or graduation thereof. That's the basic normal way that most divorce cases are resolved. If your wife or ex-wife and you develop something else in writing, providing for a college fund extension of that, then that would obligate you for whatever time you signed in your agreement with the final settlement agreement.
Yep. So Robert, there's two things that we need to get to look at. First of all is that divorce decree, the final judgment of divorce, and the second thing is if you had an arrearage with the state of Florida, that might be some reason why it is being continued on into your 60s and well after the children have been emancipated. But a great question to start out tonight. Thank you, Robert, for your call.